Joumana Kayrouz. You've seen her images on giant billboards across the metro. Joumana Kayrouz. You've seen her images on buses across the city. Now get to know Joumana Kayrouz.
The war broke out in my home country, Lebanon. I was 11 years old, and I saw a lot of bloodshed and inequality and poverty. You can't grow up in an environment like that and not be affected by it and not want to make a difference. I graduated from Yale University with a master's in ethics. I speak 4 languages. It has always been innate in me fighting for the underdog and trying to do whatever it is I can to make a difference in the world.
Let Joumana Kayrouz protect your rights. Call the law offices of Joumana Kayrouz at 1-866-YOUR-RIGHTS, extension 100, or visit yourrights.com.
برنامج يور رايتس مع المحامية جومانا كيروز المختصة في قضايا حوادث السيارات مع نخبة من المحامين في اختصاصات عدة منها الطلاق والهجرة والإفلاس يأتيكم الآن على الهواء مباشرة.
صباح الخير، صباح الخير لكل المستمعين. اليوم رامي صادق مش موجود معنا، وإنما السيدة كالي معنا هون، كالي وايت بالاستوديو. Thank you كالي very much. بنشكرك إنه you are covering for رامي. صباح الخير لكل المستمعين. مثل كل نهار أربعة منخصص ساعة من الساعة 1 للساعة 2 لنتكلم عن شيء بيسموه بالإنجليزي personal injury، يعني بالعربي إصابات شخصية. بغض النظر إذا الإصابة الشخصية يعني إصابة للشخص، إصابة لجسد الإنسان، كان سببها حادث سيارة، كان سببها خطأ طبي، كان سببها انزلاق، كان سببها criminal shooting، كان سببها criminal conduct. بنتكلم عن هيدي الأمور كل نهار أربعاء، وإنما بالتحديد مرة بالشهر بالمعدل give or take بنستضيف المحامي هاورد رادنر اللي عنده أكثر من 40 سنة خبرة. more than 40 years experience. 43.
Next month will be 45.
Oh, you're not talking into the...
Sure.
Thank
That
you.
better?
Yes, if you can turn it this way. Thank you.
Good.
It will be 45 years.
45 years next month.
45 years.
Next month.
45 years.
45.
Okay.
Next month.
Next month. Congratulations.
Thank you.
تقريبا بالمعدل مرة بالشهر بنستضيف المحامي هاورد رادنر اللي مكتبنا بيتعامل معه، واللي في وقت ما كان موظف عنا بالمكتب كمان بقضايا الانزلاق، بقضايا اللي بنسميها بالإنجليزي premises liability. يعني يمكن هي سببها انزلاق، trip and fall, slip and fall, attractive nuisance، يعني تقريبا بهذه هي المواضيع. فاليوم هو هذا اليوم من الشهر اللي بنستضيف المحامي هاورد رادنر اللي عنده تقريبا بعتذر 45 سنة خبرة. بيقول لي الشهر القادم بيصير عنده 45 سنة خبرة بهذه القضايا. بالإضافة اليوم عم نستضيف معه، هي كانت كمان مفاجأة سارة إلي أنا، تفضل وجاب زوجته معه السيدة سارة رادنر اللي هي موجودة معنا بالاستوديو، واللي هي زوجة المحامي هاورد رادنر. وحبوا اليوم ما يفترقوا عن بعضهم لأنه اليوم عيد زواجهم 40. بنتمنى لهم يا رب 40 سنة من بعدها و40 سنة فوقها، وهن أهل ل9 أولاد، وهن أهل لكتير من الأحفاد. Attorney Howard Radner, I was telling the listeners, and Sarah, I think if you can bring the microphone, you can participate in this discussion. Go ahead, get closer. You're going to be totally okay. If you raised 9 children, you know how to use a microphone. I can assure you of that. You just want to be a little bit close to it, just like I am. You raised 9 children, 9 fabulous children, lawyers and businessmen and wonderful women. And so I know you can do this. I know you can do this. So I was telling the listeners that today Attorney Howard Radner had a beautiful surprise for us. His wife, Sarah Radner, who I have had the pleasure of meeting today for the first time. And today, you two choose to be inseparable because it's your 40th wedding anniversary.
42nd.
42nd. Never mind. 42nd. 42 سنة. My goodness. And what is the secret of your success?
Marry him.
Marry him? He is that good?
He's wonderful.
He is that wonderful. That's really wonderful. Congratulations.
Thank you.
And I pray for another 42nd years and
Thank
then
you.
another 42nd on top of that.
Thank you.
Why not? Why not, Howard?
And the show could...
There's always a
and
first.
We'll be here on the show all those years.
We will be educating people and educating each other, rather you educating me about a subject that you are extremely knowledgeable about and a subject that you have had a great success in, which is the subject of premises liability. And before we start talking about this, Sarah and Howard, you have 9 children.
Thank God.
God bless them. How many boys and how many girls?
5 boys, 4 girls.
All right. And how many grandchildren?
I don't want to. I don't really know. I don't count.
But is it more than 10? More than 15?
Oh, yeah.
Yeah.
How beautiful.
Thank God.
And I have over the years received multiple texts from Howard when we have a meeting or he's coming on the radio and he will say to me that I do apologize, Joumana, I cannot make it. I am getting on a plane. My granddaughter arrived or my grandson arrived. So it seems like you make a point every time a grandchild arrives to go and be next to your children, because a number of them don't live in Michigan, correct?
That's correct.
Okay. And how many of your children, Howard, are attorneys?
2.
2.
But then we have 2 sons-in-law that are attorneys also.
So 2 sons who
2
are
sons.
attorneys and 2 sons-in-law
Right.
who are attorneys. So that's wonderful.
Thank you.
We're going to be talking about premises liability today, and I will slow down and I will translate into Arabic. We apparently have a call already. So Kelly, if you would be so kind to put the caller on the line. Hello.
Hello, hi.
يا أهلا وسهلا. Who are we talking with?
أنا اسمي كريمة.
يا أهلا وسهلا سيدة كريمة. تفضلي.
Thank you. بدي أقول له بس a happy anniversary for Howard.
Thank you.
Howard.
Thank you.
Because we already worked with him, like I think 3 years ago, and he was very, very, very nice.
Really? Was he nice and
Yeah.
was he competent or just nice?
Yeah, all of them. And we won the case. Like we went into settlement, and we won it. It was my mom.
Let me
before.
interrupt you for a minute. I want to tell you, Attorney Howard, and sometimes people choose to change their name. So don't have that frown on your face. Maybe that's not the right name, but we are so thankful to this beautiful lady.
I didn't hear her name. What is it?
Well, this is not necessarily her name. Can you give us your chosen name again, if you don't mind?
My name is Karima, and he works for my mom. My mom's case was Salima. I don't know if you remember her or not.
No problem. Her name is what?
Salima.
I remember
Salima.
Salima. I do.
Okay. Well, this is her daughter. And she is calling to thank you and to tell you it was a pleasure working with you about 3 years
It
ago.
was a pleasure working for your mother. She's a lovely lady.
Thank you. عن جد يعني كان nice معنا because my mom didn't speak English well, and like we came new for this country, so he translated for us, and he did a great job.
And are you, most importantly, in addition to him being nice and in addition to the office providing translation, are you pleased with the outcome of the case? Are you pleased with his
Akid.
competence? Akid
Yeah, for
means
sure.
absolutely.
Yeah.
Okay.
Yeah.
And without going into too much detail, was your mom's case a premises liability case, a slip and fall or a trip and fall?
Yeah.
Okay.
Yes, it was like that.
Okay. Very
And
good.
but I need to add just a little thing. You know, when you're like from different religions, you will be scared at the same time. But like when you talk to him and you will sit with him, this will go over. You know.
Say that again, Karima, please.
Like I'm saying لأنه نحن عرب وهو like أمريكاني وهيك so أول شيء بتخافي, but after you sit with him he was very very nice, even like we didn't like see the difference. We didn't.
نعم أنا فهمت اللي عم بتقوليه وأنا بشكرك على هيدا الشيء. بحب قلك إنه نحن مش كاملين بمكتبنا بس بنحاول طالما الله مقدرنا انه نتعامل مع اشخاص لو شو ما كان دينهم، للاشخاص اللي بنتعامل معهم، للاشخاص اللي بنعطيهم بزنس، للاشخاص اللي بنقبل منهم بزنس، بنتعامل مع أشخاص هن إخوتنا بالإنسانية. إذا بنحس
طبعاً.
إنه في عندهم عنصرية أو إذا بنحس إنه في عندهم كره، أخلاقيا ما بنسمح لنفسنا إنه نكمل نتعامل معهم. هذا
Yes.
الشخص بالتحديد ولا مرة شعرت من قبله انه في انحياز، لانه هو من مش بس امريكاني، بس هو من دين مختلف. لو
صح.
انا شعرت بهذا الشيء انا ما بقبل، لانه اللي ما بقبلوا علي ما بقبلوا عليك سيدة كريمة، ما بقبلوا على
كلك
امك.
صح.
مزبوط ولا لا؟
لا يا طبعا اكيد.
اوقات بتبلشي تتعاملي مع انسان وبتكتشفي اشياء عنه، ساعتها when you know better you do better. الله تعمنا انه عندنا كتير كونتاكتس بمكتبنا وبغير مكاتب بدون شك، عندنا حرية الاختيار. اذا الشخص ما كان ادمي وبذات الوقت عنده الكفاءة، بننتقل لشخص تاني يكون ادمي ويكون عنده الكفاءة. بس انا بشكرك على هيدي الجملة.
كلك صح حبيبتي. I thank him so much too.
Thank you very much. He's listening to you and he's puzzled by what we said in Arabic. She is saying, I will summarize this very briefly. She is saying that although you are not our culture, you made it very comfortable for her and you made it very comfortable for her mother. And at first, whereas somebody maybe, may think that the language barrier, the cultural barrier and other barriers may be an impediment, she came to see that with you, that was not an impediment. And so she thanks you. We thank her for taking the time to call and say this. People are very quick to complain and very slow, if not at all, hesitant or not wanting to give a good, compliment. So we thank you so much, Sayyidi Karima.
It's very nice to hear from you, crewman. Please give our best regards to your mother and your father.
I think maybe she is off the line. So سيدة كريمة بيطلب منك انه تسلمي على الوالدة وعلى الوالد. شكرا كمان مرة. اللي بحب يتصل على فكرة يعلق، او اللي بحب يحكينا بطريقة مجهولة، يعني ما يسمعنا صوته، ما يحب يعطي اسمه، بحب يعملها بطريقة برايفت واللي هي عبر الواتساب. ورقم التليفون على الواتساب هو 313-327-7074. السيدة كلمة موجودة لتتلقى اتصالاتكم على الواتساب. فيكم تتركوا فويس نوت أو فيكم تتركوا كتابة نصية بتقريون وبتوصلنا المسج كمان. وليلي بحب يتصل على 313-769-6666 ومن وينزر 519-256-1023. أنا اليوم أوقات موضوع البريمسز liability، يعني قضايا الانزلاق إلى آخره، أوقات شوي منحلي أكتر مما لازم. اليوم حبيت نرجع شوي back to the basics. أول نقطة بحب وصلها للمستمعين وذكر بعضنا البعض فيها، إنه كقاعدة عامة ليقدر إنسان يقيم دعوة وينجح فيها. أي إنسان بيقدر يقيم دعوة، أي شخص تاني للأسف مش مفروض تكون frivolous، بس relatively easy إنه إنسان يقيم دعوة ضد شخص آخر. بس ليقيم دعوة ويكون في استمرارية بالدعوة وينجح بالدعوة، بده يفرجي إنه صار في شيء، صار في إساءة، صار في a bad outcome، وبده يفرجي إهمال. يعني أوقات bad outcomes happen، أوقات بيصير أشياء سلبية، أوقات بيصير أشياء مش لمصلحة الشخص، وإنما ما بيكون نتيجة إهمال. القانون بيقول طبعا الشخص اللي بيفوت ليعمل عملية لا سمح الله بيتوقع a good outcome مش a bad outcome. الإنسان اللي عم بيسوق سيارة، الإنسان اللي ماشي على الطريق، طبعا بحق لكل إنسان إذا تعرض لإساءة من نوع أو من آخر يسأل حاله السؤال: هل اللي صار معي أو هل اللي صار to a loved one هو سببه negligence، هو سببه إهمال من طرف آخر؟ وإذا ما قدرنا وصلنا الأوتكم اللي هو سلبي بإهمال من طرف معين، ما بنقدر نقدم دعوة، نستمر بالدعوة ونربح الدعوة. هيدي أول نقطة حبيت وصلها اليوم. بحق لكل إنسان صار معه شيء سيء يسأل حاله هيدا السؤال. وكتير أوقات الشخص ما قادر بلا مساعدة خبير، بلا مساعدة محامي يجاوب على السؤال. مثلا لا سمح الله إنسان بفوت على المستشفى وبيطلع with a bad outcome، أو لا سمح الله بيصير في وفاة أو بيصير عملية ما بتنجح، بحق له يسأل نفسه هل صار هيدا الشيء بسبب إهمال من قبل أي شخص connected with the medical community، إن كان النيرس، إن كان الفارماسي، إن كان السيرجن، إن كان الأنستيزيولوجيست إلى آخره. ودائما الجواب بيكون بالملفات الطبية من بعد ما المحامي يطلع عليها ويبعتها لخبراء بذات الاختصاص. ذات الشيء للأشخاص اللي بيتعرضوا لإنزلاق، اللي بيتعرضوا لبريمسز انجري. كمان الإصابة وحدة غير كافية، بس هذا الشخص بحق له يستعلم عن القانون ليسأل نفسه إذا هذه الإصابة في وراها إهمال من قبل شخص. بعطي مثل، نحن أصحاب مكتب، لنقول شخص من الموكلين فات لعنا على المكتب ونحن حاطين شيء بالأرض، مش مفروض نحطه بالأرض، إهمال من قبلنا إنه هذا الشخص إنه نحط شيء بالأرض لحتى يتفركش عليه مثل ما قولوا باللبنان الدارج، أو يوقع الشخص من وراء اللي محطوط على الأرض. إذا الشخص وقع وصار عنده شيء سيء، بحق له يسأل نفسه هل هذا بسبب إهمال من قبلي؟ والإهمال مش دايما بديهي بقانون البريمسز لايبيليتي بميشيغان. رح أعطي مثل، وإذا جاوبتكم إنه أنا ما أهملت هل بتصدقوني؟ لمي إكسبلين. إذا لا سمح الله أنا حاطة شيء بالأرض وإجا موكل وتفركش ووقع وتعرض لإصابة، هل بحق له هيدا الإنسان يقدم دعوة ضدي ويربحها؟ الأرجح لا. ليه؟ مزبوط أنا أهملت، ومزبوط ما كان لازم حط شيء بالأرض، وإنما القانون للأسف بميشيغان قانون صارم جدا. مشان هيك بستضيف المحامي هاورد رادنر، لأنه في كتير محاميين في ولاية ميشيغان no longer accept these cases، ما بقى يتقبلوا cases premises liability، لأنه المحكمة العليا في ولاية ميشيغان طلعت عقيدة doctrine بيسموها open and obvious. يعني إذا كانت واضحة للإنسان شو في على الأرض، شو في قدامه، شو في قدام عيونه، شو في قدام مسمعه، كان في هو يتحاشى الإصابة، وبالتالي إهمال الآخر ما عاد هو السبب ليش تعرض لإصابة. يعني in my case إذا أنا حطيت شيء على الأرض، صحيح هيدا إهمال من قبلي، ممكن كتير يكون إهمال من قبلي، وصحيح إنه الشخص تفركش. القانون في ولاية ميشيغان بيقول wait a minute، هذا الشخص of ordinary negligence of ordinary intelligence، بعتذر، هذا الشخص اللي عنده عيون لا تقشع، واللي عنده دينين لا تسمع، واللي عنده على الأقل ordinary intelligence، ما انتبه إنه في شيء على الأرض. لو كان مركز، لو كان منتبه، كان بيقدر يتحاشى يوقع. الإهمال مش إهمال اللي سبب الإصابة، عدم إدراك الشخص هو اللي منعه من إنه ينتبه، يزيح على جنب ويتحاشى الإصابة. هيدي النقطة اللي اليوم بدنا نحكي عنها شوي بطريقة مفصلة أكتر. Attorney Howard Radner, I wanted to start today by going back to the basics and explaining to people that number one, a bad outcome in and of itself does not necessarily mean that there have been negligence. I want you, by the way, I want to tell the listeners that I seem to do a lot of the talking in our shows because you are much too polite to interrupt me. And then every time I say, please interrupt me, you are the expert, I'm not. And then you say, are you sure? Until last time. And then you promised me last time that you're going to interrupt because we want to hear from you. You're the one with 45 years of premises liability experience, not me.
Well, today I have to be on my best behavior.
You are going to be on your best behavior,
My
but
wife
you're
is
not right now because you're talking to me and not into the speaker.
Oh.
Okay. So I can hear you all right, and Sarah can hear you all right, and Kelly can hear you, but our listeners don't hear you clearly. So is it correct that a bad outcome in and of itself is not sufficient?
That's right. People call oftentimes they fell somewhere at a friend's house, at a store, at a gas station, and they got injured. And they
And they
obviously
think that that is enough.
they're calling a lawyer, so they think that there's compensation.
Now, you're not saying to our listeners, do not call a lawyer, because they simply do not know. They don't have enough information to make that determination on their own. So they are right to call a lawyer, correct?
Absolutely.
Okay. And
But
then,
it's what I want to say was that it's not enough just to fall on somebody's property and then be entitled to receive money damages. That's not enough under the law.
what do you need to show under the law? So now we have a bad outcome. We have a broken bone.
Mm-hmm.
We have a herniated disc. We have a surgery. We have a tear. The injury is there. And we know there is something that caused the injury, whether it is a hole on the street, you know, what is it called? You fall
a
into
pothole?
a pothole,
Mm-hmm.
a pothole in the street or something in a store, you know, like a lid or whatever. So we know there are certain facts, and we know we have an injury. What more do we need?
So you'd have to show, for instance, if there's a fall on a liquid in a store, that an employee knew that liquid was there and ignored it, didn't clean it up, didn't put up a caution sign, just ignored it and went about her business. That would be a case of negligence.
Okay, what
But if you
about...
can't prove that, if you can't prove that the store employees knew about that liquid on the floor and had no reason to know about it, then you can't sue them because there's no negligence.
How about if the liquid on the floor is gray and the liquid on the floor is brown?
That's another problem. Now you're running into open and obvious.
Okay.
So that there, even if you can prove that the employees knew that the brown liquid was on the floor for a long time and ignored it, you still may not be able to recover damages.
And sometimes
because
you don't intentionally
open and
ignore it. You're
obvious.
busy working on your cell phone or looking somewhere else.
Right, so the store is going to take the position that the customer that fell in that brown solution should have seen it and walked around it
Okay.
because it was open and obvious.
In other words, open and obvious means, yes, there is something on the floor. And even assuming the store knew about it and should have cleaned it and it didn't clean it or totally ignored it, you have eyes to see, you have ears to hear, you have at least an ordinary intelligence to look down and see what is there to be seen if you chose to see. You can see brown on gray. Maybe you cannot see transparent on gray, but you can see brown on gray. And the law here in Michigan says, well, it's obvious. Why weren't you looking? Had you been looking, regardless of the store's negligence, had you been looking, you would have avoided that injury. So it's on you. You should have looked. Had you looked, you would not have been hurt. You did not look, doesn't matter what the reason is. You were distracted, like we all are with our cell phones. You did not look, and so you caused yourself that injury.
That's right.
You could have avoided it. That's
under the old
and
law,
obvious.
before we had open and obvious, that would be a case for the customer.
When
because
did the open and obvious doctrine?
That started in 2001 with the Supreme Court deciding the case of Lugo versus Ameritech. But before that, we had pure comparative negligence, so that if let's say the store employees were negligent in leaving a brown solution on the floor and didn't bother cleaning it up, and they knew about it, they walked by it, they didn't put up a sign, they didn't call for maintenance to mop it up, and then along comes a customer. The customer is not looking down on the floor. She's looking straight ahead.
She's
So
looking
she
at the
falls on it.
shelves.
Under the old law, that case would actually go to a jury, because then the jury would be asked, was the store negligent? Yes or no? If yes, was the plaintiff negligent? Yes or no? What degree of negligence do you attribute to the plaintiff? 33%. Very well. And what were the damages? $100,000. So then in that case, the plaintiff would walk away with $66,000. That's the old law. Then they changed it so that now that plaintiff would get nothing.
Is Lugo versus Ameritech the case of the blind person?
No. Lugo was a case. Mrs. Lugo was walking in a parking lot that was owned by Ameritech. And she was looking up because she claimed that there was traffic in the parking lot. So she's looking for the cars. And she walked into a pothole and broke her leg. And the court said, our Supreme Court said, basically, that because that pothole was open and obvious, she couldn't recover anything.
So clearly that pothole was big enough,
Yes.
visible to the eye, clearly enough that had she looked, she would have
She would have
avoided
seen it. And here, the Ameritech was obviously negligent in letting their parking lot deteriorate such that it had a pothole. They had a duty, you would think,
But it
to maintain
wasn't.
their property.
So they were negligent, but it wasn't their negligence, according to the Michigan Supreme Court, that caused her to fall. It's her own negligence in not looking down and seeing what is there to
And
be
therefore,
seen.
she received nothing.
Okay, so the case that changed everything, الكيس من المحكمة العليا في ولاية ميشيغان اللي غير كل شيء هو الكيس بسنة 2001 اللي اسمه لوغو versus أمريتك. المحكمة العليا بميشيغان قالت انه السيدة لوغو هي كانت مغلطة، كانت ماشية بباركينج لوت لأمريتك، عيونها لقدام لأنه عم تطلع على السيارات، لأنه كان في كتير سيارات ما بدها تنضرب من إبر سيارة. وقعت زحطت على جورة بقلب الباركينج لوت تبع أمريتك. قامت دعوة ضد أمريتك، طلع الكيس للمحكمة العليا. المحكمة العليا بتقول اللي صار معه هو مش بسبب الإهمال من قبل أمريتك. نعم كان في إهمال من قبل أمريتك، بس مش الإهمال من قبل أمريتك هو اللي سبب الإصابة لهيدي السيدة. مظبوط كان في إهمال من قبل أمريتك، لأنه أمريتك كان مفروض تكون عم بتظبط الطرقات تبعها، مش مفروض تسمح لجورة بهالسايز أنه تضل موجودة. وإنما الجورة كانت كبيرة لدرجة أنه لو سيدة لوغو عم تطلع على الأرض مثل ما مفروض تطلع، عندها عيون لتقشع وعندها ذهن لتفهم أنه لازم تزيح على جنب لحتى ما توقع بقلب الجورة، لأنه ما اطلعت على تحت بس اطلعت لقدام، الحق طلع عليها. يعني لو هي انتبهت على الأرض وحكمت عقليتها مثل ما a reasonable person of ordinary negligence would do، كان فيها تتحاشى هيدي الجورة وكانت الإصابة ما صارت. هيدا هو القانون اللي هو صعب كتير بميشيغان، اللي هو غير منصف بميشيغان، اللي نحن المحاميين on behalf of our clients منعاني منه من 2001، اللي in essence بيقول يعني in other words عم بيقول you have to be like a dog with your nose to the ground. بس نحن إنسان، نحن ما فينا نطلع بالأرض كل الوقت. لوين بدهم يكونوا عيوننا؟ بدهم يكونوا عيوننا لقدام وبدهم يكونوا عيوننا على تحت. للأسف المحكمة العليا مش هيك ما في كتير محاميين بيقبلوا هول الكيسز. هاورد رادن هو من المحاميين القليل اللي بيتقبلوا هول الكيسز، مشان هيك عمل لحاله اسم كتير كبير وعنده نجاحات بأرقام مادية كتير عالية، لأنه أغلبية المحاميين ما بدهم وجع الراس، بيرفضوا البريمسز لايبيليتي كيسز من أولها لحتى ما يجازفوا إنه ياخدوا الكيس ويقدم الطرف الآخر شيء بيسموه motion for summary disposition، إنه it was open and obvious، ويزتوا الملف برا. هيدا اللي نحن منعاني منه بولاية ميشيغان. يعني لنحكي عمليا، المحكمة العليا عم بتقول إنه نحن مفروض نطلع قدام ونطلع حوالينا ونطلع على الأرض نحن وماشيين، وإذا شيء أي شخص of ordinary negligence، مش الشخص بالتحديد، أي شخص of ordinary negligence، وأي شخص the reasonable person على فكرة هو a person، هيك بتقول المحكمة، إذا a reasonable person could have seen, could have heard, could have avoided of ordinary negligence, then this person should have avoided. يعني إذا الإنسان أعمى وعم يمشي على الأرض وفي جورة على الأرض، والإنسان the reasonable person، على فكرة تقول المحكمة العليا صدقوا أو لا تصدقوا أنه a reasonable person هو إنسان بيقشع. في كيس لشخص أعمى خسر الملف تبعه للأسف لأنه وقع بجورة، والمحكمة قالت sorry but a reasonable person، يا عمي هو منه reasonable person، هو رجل أعمى، he's a blind man. no، المحكمة بتقول a reasonable person يعني الإنسان العادي، إنسان بيقشع، إنسان بيسمع، وإنسان عنده ذكاء على الأقل متوسط. وإذا الإنسان اللي بيقشع بيسمع وعنده ذكاء متوسط كان في يتحاشى اللي موجود، هذا الشخص اللي قيم دعوة في يتحاشى وبالتالي بيخسر. يعني حتى لو في إهمال من طرف آخر، إذا كان مش الإهمال تبع الطرف الآخر اللي وصل الإصابة الودى للإصابة، لا بالحرى عدم إدراك أو عدم انتباه الشخص اللي ماشي لحتى يتحاشى الإصابة هي اللي سببت الإصابة، وبالتالي هذا الشخص ما بيقدر يقدم دعوة ضد الشخص الثاني وينجح فيها. مثل ما بلوغو كان في إهمال من قبل الباركينج لوت، كان لازم يصلحوا all the potholes، بس كانت كبيرة لدرجة إنه كان فيها تتحاشاها. يعني خلاصة الأمر نحن وقت اللي بنمشي من الضروري جدا نتطلع قدامنا وعنا peripheral vision، يعني بنتطلع يمين وشمال، ومفروض كمان نتطلع على الأرض. طبعا وقت بيصير في سنو وآيس بتختلف شوي الأمور، لأنه أوقات السنو كفرز آيس، هيدا موضوع مختلف آخر، وهون السؤال بيصير هل هي واضحة للريزنبل بيرسون على شو عم يدعس إلى آخره. كمان مرة بحب ردد أنه نحن مثل كل نهار أربعاء بنتكلم عن الإصابات الشخصية تقريبا بالمعدل مرة بالشهر. نستضيف المحامي هاورد رادنر اللي بيحكينا عن الإصابات slip and fall, trip and fall إلى آخره. By the way, I think I mentioned this case in a previous show, maybe about a month or 2 months ago, but since we're talking about open and obvious, the Court of Appeals, let me tell the facts. A concert goer, somebody went to attend a concert at night and decided to go to the nearby woods and go to the bathroom instead of the well-lit areas where the bathroom was provided by the venue there, and slipped and fell or something to the sort, and sued the promoter, the concert promoter, as well as the concert itself, Michigan International Speedway and Live Nation. So sued because she broke her ankle in the nearby woods while she was leaving the music festival. The case went from the lower court to the Court of Appeals, and the Court of Appeals said to the lady, "We are really sorry. It was open and obvious. It was obvious to you that you are leaving the premises and you're going into a woodsy area. You should have known that the woodsy area is not certain, it's not well lit. There is no telling what's on the ground. It wasn't part of what the concert provided for you. And you could have avoided any." The court applied the open and obvious and said that any reasonable person of ordinary negligence should know better to go to the bathroom stall provided in the concert rather than to this woodsy area, because the bathroom stall that's provided by the concert is well lit and is, safe, but the area that, you chose to go to is not. And so it was obvious to the reasonable person of ordinary negligence to avoid that area. And the Michigan Court of Appeals said that, it was completely avoidable. Why did you need to go into a woodsy area when the path, leading to the bathroom stalls provided by the concert were very well lit? So the Court of Appeals, any comments on that? The Court of Appeals said to the lady, "Sorry, tough luck. Under the doctrine of open and obvious, it was obvious that this was unsafe and you had another way to go to the bathroom." That reminds me of when you talk about the common areas and how if there is no other way to leave from like a apartment building common area over snow and ice to go to your car, and there are no other ways, that is more in your favor against the landlord than if there were other ways. And the Court of Appeal said the same thing here.
Yeah, I mean, that would be effectively unavoidable,
right?
What you just described now. But in that case that you mentioned, I wonder if the promoter had any control of the woodsy area where she wandered off to, and if there was a bathroom there.
It does not look like the woodsy area was maintained at all. It seems like there was absolutely no reason. It looks like this concert goer did not want to use the bathroom stall that has been used by hundreds of people and may be dirty, and wanted to go on her own. That's what it looks like. So it does not look like the woodsy area was under the control of the promoter. No evidence of that whatsoever.
If it wasn't under the control of the promoter, then the promoter has no duty to maintain it. And there's no way that the promoter could be held liable.
So there too, the Michigan Court of Appeals said under the doctrine of open and obvious to the reasonable person. Open means what exactly? Open to what or to whom?
Noticeable. Visible.
Noticeable. Open,
Visible.
visible. Open meaning visible. Obvious meaning with every one of your five senses, it's obvious that a hazardous action is there that can be avoided, that should be avoided. Correct?
Right.
Correct. Okay. TJMAX in Pennsylvania was sued, and I know it's Pennsylvania, so we'll talk about Michigan, but TJMAX in Pennsylvania was sued by a lady who was trying high heels, a pair of high heels, and she slipped because the store floor was slippery and shiny. No liquid. It was slippery and shiny. Next thing she knows, she slipped and, she was hurt. So she decided to sue TJMAX. She sued TJMAX. She also sued the cleaning company with which TJMAX subcontracts for cleaning their stores. And she also sued the floor waxing company that also subcontracts, or that TJMAX subcontracts with, to wax their floors. They were sued, and she lost her case in Pennsylvania because the court said, where is the dangerous condition? She said, the court said, yes, assuming that the floor was slippery and shiny, how is the jury gonna determine what exactly caused you to fall? A shiny floor in and of itself is not enough. If this were in Michigan, how would the argument go?
First of all, the
court said if there was a liquid, and depending on the color of the liquid, then the jury has something to work with. And you can ask the jury whether this is a hazardous condition that she could have avoided or not avoided, and so forth.
I mean, it would be far-fetched for me to think that in Michigan the lady would succeed.
Because
there's no defect.
Meaning you think she will not succeed in
She will
suing
not.
TJMAX.
There's no
Why?
defect here on the floor. There's no defective condition. There's nothing that TJMAX did that was improper. It's not improper to wax your floor to keep it clean.
What about
If they let it get dirty, that would be a defective condition. They have to keep it clean.
what about the fact that it's shiny?
That's not considered a defect. Floors always shine when they're clean, when they're waxed.
What about
How
if
do you
true?
clean a floor and it not be shiny?
How about if it was indeed slippery?
No, I don't see a case. I mean, floors are inherently slippery. There's nothing you can do to make them unslippery.
So this is yet another example of how, right or wrong, the law doesn't always go far to protect people. And I think what we need to remind each other, especially in today's technology age, where we're very distracted by what we're holding in our hands, if not other things. We don't want to get an injury, and we don't want to sue, and we don't want money. We really want to prevent an injury, like Harry Philo used to say. But when that fails, then we sue for money compensation. So I think the advice to one another here is we have to be careful. We have to be vigilant as much as we can, because the law may not, fair or not, may not go far to protect us in the event of an injury. I don't think anybody wishes to slip and fall and go through tens and tens and tens of physical therapy sessions and testing and, injuries and surgeries and physical therapy after surgeries and rehabilitation and, no amount in the world, and you're never back to who you were. Your body is never back to what it started. So really, whichever way you think about it, the best thing is the prevention of injury, and it's on us as the customers, wherever we go, to be very careful, very vigilant. Take that extra minute, because that extra minute can save us tens and tens and tens and hundreds of hours of pain, suffering, treatment, rehabilitation. Correct?
And here in Michigan, really, you have to look where you're walking at all times.
You have to look where you're walking at all times. Snow and ice, driving from point A to point B, allowing extra time. And when you do not have the extra time, so be it. Arrive late. Better arrive late and safe, and having kept other people as safe as possible, than risking an injury to yourself and or others. Correct?
Sure.
هون بفتكر النصيحة إنه مثل ما بنشوف القانون هون بميشيغان صارم جدا، وكتير أوقات القانون منه صارم لدرجة منه بيحمي لدرجة كافية المستهلكين. يعني لربما النصيحة هون لبعضنا البعض إنه نكون حريصين وين منمشي، نكون حريصين عم نطلع قدامنا، نكون حريصين عم نطلع to be in the now. أغلبيتنا are not in the now. أنا أولهم. We're not in the now. We're in what we did, what we're doing. We're not in the now. كتير مهم إنه نكون كتير حريصين. نحنا وين؟ شو عم نعمل؟ عشو داعسين؟ لوين داعسين؟ شو في قدامنا؟ شو في عكعب إجرينا؟ شو في عيميننا؟ شو في عيسارنا؟ وإذا هيدا الشيء بده يبطئنا شوي 30 ثانية ودقيقة و10 دقايق فليكن، على القليل منوصل بإذن الله سليمين، نحن سليمين والآخرين سليمين. إذا كنا بسيارة سلامتنا وسلامة غيرنا، إذا كنا بستور، إذا كنا على الشارع، إذا كنا على الطريق. أنا مثلا اكتشفت أنه أوقات وقت بطلع من السيارة مثلا لنقول عم بمشي من السيارة للراديو ستيشن، في عندي تقريبا 20 ثانية، أول إنستينكت أنه افتح السيلفون تبعي وأطلع. صرت انتبه، صرت يا ما بعملها يا بوقف بنص أرضي بس بمحل سيف obviously مش بنص الطريق، بفتح التليفون بقرأ اللي بدي اقريه، بجاوب على اللي بدي جاوبه، وبرجع بكمل على طريقي. ودائما بنقول انه احسن الانسان يوصل مأخر نص ساعة وربع ساعة وساعة وما يوصل من انه يوصل من انه لا سمح الله يعرض حاله او يعرض غيره لأي إصابة. هيدي رح توصلنا بعدين ونوفر الدقيقة وال10 دقايق والنص ساعة، رح توصلنا لداهية إن كان إلنا ولا إن كان للآخرين. رح توصلنا لمكان يمكن نضطر نتعالج من وراء عشرات وعشرات الفيزيكال ثيرابي سيشنز، يمكن عمليات، علاج من بعد العمليات. إذا فينا نتحاشى هيدا الشيء، لأنه نحن أكتر in the now، نحن موجودين باللي عم نعمله، مركزين على اللي عم نعمله، مركزين على المكان اللي نحن موجودين فيه. نحن مش بالماضي، نحن مش بالمستقبل، نحن بالحاضر. في كتاب تذكرت كتاب بيسموه The Power of Now. هذا الكتاب البريمس تبعه مختلف بس اسمه التايتل تبعه The Power of Now. كان على النيويورك تايمز بس سيلرز ليست لأسابيع ويمكن شهور عديدة. Have you heard of the book Eckhart Tolle, The Power of Now? Well, it was on the New York Times bestsellers list for I think months on end. Regardless of it's a spiritual book, and Oprah promoted it a lot at the time, but I think it drives the point that if we try, we don't want to have legal recourses. First, we see that the law here in Michigan is very tough. With this open and obvious, they expect you to be a dog with your nose to the ground. You're not a dog. You are 5 feet tall. You are 6 feet tall. It's very hard. Where are you going to look? In front of you and to your sides and but that's what they expect you. So the law doesn't go far to protect you. Better, and I don't know of anyone who wishes an injury upon herself or himself only to make money. I don't know of anyone who desires that.
Supplement what we've said so far. In the Lugo case,
I see that you are interrupting me today.
The court, well,
how very disrespectful.
My wife will have to forgive me.
Your wife approves because she knows that's what we want. We want to hear from you.
So let's not forget in the Lugo case, the court did say that if there are special aspects, then the open and obvious doctrine may not bar the plaintiff from suing the property owner. And
maybe
they gave
next
two
time
examples.
We'll talk about that. Yes, but go ahead.
Our
please,
two examples
please.
are if something is, say, a 30-foot deep pit that's so dangerous that would not bar the plaintiff from suing, even though the pit is open and obvious. The other example the court gave...
Give that example again.
Sure, a 30-foot deep pit on somebody's grounds would
Even
be
if you can
so
avoid
dangerous. Right.
Even if you can go
even
around
if you can
it.
avoid it, because it's so dangerous that the open and obvious doctrine may not bar a person from suing.
Is that in essence kind of punishing the defendant for allowing a condition to be so dangerous on
it's
their
just
premises?
saying that even though it's open and obvious, they are so negligent in allowing such a big defect on their property,
so it's punishing
that the court is not going to let them get off. The other example the court gave was if something is effectively unavoidable. And the example they gave there was somebody trying to leave a building, and there's a puddle at the only exit. The person must walk through that exit. So if he falls in that puddle, the premises owner cannot say it's open and obvious.
Wonderful. So بيقول المحامي انه الكيس تبع لوغو اللي طلع بال2001 من المحكمة العليا اللي بيقول انه اذا في الانسان يقدر يتحاشى الإهمال اللي موجود واجباته يتحاشاها، وإذا ما تحاشاها الغلطة منه مش الغلطة من اللي خلق الإهمال، وإنما في طريقتين استثنائية المحكمة بتسامح الشخص حتى لو كان بيقدر يتحاشاها، أو وحدة منهم كان بيقدر يتحاشاها إذا كان اللي موجود إهمال فظيع لدرجة حتى لو الإنسان إذا عنده عيون يقشع بيقدر يتحاشاها. المحكمة بتقول برضو رح نصف مع الشخص اللي تأذى، لأنه ما بنسمح إنه owners يسمحوا إنه يكون في وضع على أراضيهم لهالدرجة في إهمال. مثلا بلوغو قالوا إذا الحفرة كانت 30 قدم غميقة، مع إنه الشخص لو منتبه وعنده عيون يقشع كان شايفها، بيقدر إذا تعرض لإصابة مع إنه كان في يتحاشاها، القانون رح يجازي صاحب الأرض، لأنه ما لازم إهماله يكون لدرجة إنه سامح إنه يكون على أراضيه في condition لهالدرجة خطرة، a condition so dangerous. يعني حفرة 30 قدم هيدي ما لازم أي أونر يسمح أنه تكون موجودة على أراضيه، حتى لو كان الإنسان اللي ماشي لو كان منتبه كان بيقدر يتحاشاها. والطريقة الثانية اللي شوي حكينا عنها قبل، أنه إذا في شيء موجود وشافه الشخص بس ما بيقدر يقفز عنه، ما بيقدر يتحاشاه، ما بيقدر to go around it، ما عنده غير طريقة يقطع من point A ل point B إلا يطلع هاي الكونديشن، بغض النظر إنه واضحة إنه الكونديشن خطرة. شو بده يعمل الإنسان ساعتها إذا قطع عليها وتعرض لإصابة مع إنه شافها بس ما كان في يتحاشاها؟ the condition was unavoidable. so هيدي الكونديشن تاني اللي حكي عنها المحامي هاورد رادنر. Two conditions that apply to Lugo. We talked about the TJMAX. We have about 6 minutes. I don't want to talk about the duty of landowners to take responsibility for the safety of their visitors. It's becoming a bigger issue. Say like abortion clinics and so forth. Maybe next month we'll talk about that. Or maybe hotels, ATM machines, criminal conduct, and whether a landowner, should have known because of what's happening, that criminal conduct can happen around that area and should have taken extra measures for the safety of the visitors. But maybe we'll talk again about something we discussed in the past. Sarah, is there something you want to say?
Fascinating topic.
These are the new, if you want to get closer to the microphone, Sarah, these are not your classic anymore premises liability cases, but they're coming under the premises liability cases, concert goers, stadium attendees, now criminal conduct. You wanted to say something?
It's the kind of thing you don't think of when you think of in terms of
Premises
liability. It's just an interesting new take on it.
Right,
like,
new
I
trends.
can see that there'll be new law
Yes.
to take heart.
Yes,
Yeah.
and there have been cases across the nation. Now MGM was sued by, I believe, a class action of people for the shooting that happened in Las Vegas, the Las Vegas shooter, and the argument is that the hotel should have a reasonable hotel would have known that somebody can come and commit a crime and should have taken additional reasonable
But here in Michigan, we have
steps.
the Williams versus Cunningham's case.
Oh, I'm not
from
aware
the
about
80s, where we have somebody attacked by a criminal on the premises. Court said that Cunningham's didn't owe a duty to anticipate a criminal act. Therefore, there was no case there. The plaintiff could not recover. That's still the law in Michigan, as far as I know.
Do we have a call, by the way? Yes. Okay. So maybe next month, God willing, we'll talk more about those, and we will pick up the case in Michigan of Williams versus Cunningham, where the Michigan Supreme Court did say there is no duty to anticipate a criminal act. That does not mean that the Michigan Supreme Court will not come in the light of today's world to change its mind. Correct or
That's
correct?
possible.
Thank you. We have 4 minutes. Let's take a call. Hello?
Hi, good afternoon.
Well, good afternoon to you.
First of all, thank you for the information and incitement. I really appreciate it.
Thank you so much.
The second thing, just a minute ago, you mentioned the law where you said if there is a hazard unavoidable, and a person sometimes cross that hazard because he cannot go around it, avoid it, and that whomever do the hazard will be accountable.
It's correct.
Now, the question is, that law apply to the city or to the state or to the government?
To the government, to a government entity.
Yes.
Wonderful
sometimes
question.
you're in the middle of the road and a big hole or bad roads, and you either hurt yourself or hurt your car, or you have to maneuver so you can avoid that and you get into an accident or something like that. Can that be applied to the government?
Who are we speaking with?
My name is Shihab.
Shihab. Shihab is asking a question about whether or not there is what we call governmental immunity, when the same condition we talked about, an unavoidable dangerous condition, happens when whoever is responsible for that unavoidable dangerous condition happens to be the government.
Yeah, I mean, that would be a valid case because the government has
apply.
a duty. No, the whole effectively unavoidable issue only applies to a premises liability case. This, what you described, sir, is non-premises liability, but this is a highway defect, and the city, county, or state would be responsible
even if
for
it is
damages.
a sidewalk?
Sure.